Page 1.
Question number 06. Page 1 document of admission. Page number 9, seal number 51 to 56. 56.
Why not? Inform the other side. Learned counsel submits that he has already informed the other side. At his request, list is smarter on 28.
Page number 10, seal number 57 to 65.
My lord, serial number 58, my lord. A week's time may be given because it is heard from the private advocates that the matter has already been compromised, my lord. We have asked the private
He submitted that the matter is already settled between the parties. For filing a memo in that regard, counsel seeks time. This is smarter on 29. Yes.
Council of the court has some limited inform.
Which case?
60.
Inform the other side.
Yes, inform.
62 at the request of counsel the petitioner on 26.
Please.
Yes.
Page number 11, seal number 66 to 73.
Yes.
serial number 17, my lord, application for transfer number. There is some likelihood of settlement, my lord. Matter may kindly be represented.
Have you informed the other side?
Yes, sir. All for response.
You submitted that there is a likelihood of settlement. List is marked on 27.
Interim order may kindly be.
Intermod order granted is extended till then.
Page number 12, seal number 74 to 80.
My lord, serial number 74, my lord. For the petitioner, my lord, some inconvenience today, my lord. Can be on Monday, my lord. I had my
Respondent.
for the petitioner.
Respondent have you informed?
My lords, the respondent has yesterday, my lords heard the matter. Respondent has not came, my lords. So it was listed today, my lords. The respondent.
You have to inform him.
is
I think
not-
he has come, will be. He's there in the court law. That's your duty to inform. Yesterday also, one advocate, without even informing the other side, he mentioned, and he was waiting till such time. And when the matter came up, I posted it to today, and I imposed cost of rupees 1,000 on the advocate. I'm making it very clear to the advocates. Inform the other side, or else you have to wait till the matter reaches.
Please.
Yes, please wait till the matter reaches. Yes.
This number 1, non-compliance process objections.
Serial number 77. My lords, petition for the petitioner, my lords. I will inform the respondent. My lords, my senior had to take up emergency travel today morning, my lords. Serial number 77, my lords, I will next week, my lords.
The request of counsel the petitioner. This is marked on 27.
My lords, serial number 79, my lords. I am for the respondent, my lords. I also informed the petitioner counsel.
77 and 79
Yes.
on 27.
Serial number 18, matter supplied, I do withdraw memo by the party. Sorry.
Serial number,
18, 18.
you file the memo.
I will file withdraw memo.
When?
Because matter is 2-3 days later.
18, listed is submitted that for filing a withdrawal memo, learned counsel seeks time. This is matter on Monday.
Please, yes.
My lords, serial number 43, my lords. Matter has been settled from
Where were you yesterday?
Because my health was not good, my lords. So late, I couldn't able to appear for this court.
Then no colleagues also. What happened day before yesterday?
Last one, 3 days, my lords, I didn't come to the court.
No, you could have asked somebody. You're the only one. No colleagues will help you. No, because I'm not able to understand this trend here. Matters being posted to dismissal, you let it dismiss.
Sorry, my
Very
lords.
casually. What will happen to the client here?
Sorry, I will file the record.
Yesterday, if I remember, I dismissed 2 of your matters for dismissal.
My health was not good, my lords. Last one, 3 days.
Then colleagues will not, nobody will help you in that in the profession.
Sorry.
No, it is like casual approach of the advocate is, okay, let it be dismissed. Again, I'll file a
Sorry.
application for recall that will be done. No.
Sorry.
Yes. 43. You filed a memo. File it.
Yes, password.
It is sub. Is 40. Password.
Non-compliance of process objection. For first time, serial number, motion signed 20.
For 2 weeks.
23 matter. Sign. Default. Yes, next.
Seal number 2, J. Shetty.
Week's time before order.
Seal number 3, Vijay Madali.
Week's time before order.
Seal number 4, Vijay Karnataka.
A week's time before order. Yes.
Seal number 5, Vijay Karnataka.
In these two matters, 4 and 5 for dismissal. Yes. 4 and 5 for dismissal tomorrow. Yes, next.
Non-compliance of office subsection for second time. Seal number 6, escape act.
This also for dismissal tomorrow.
Seal number 7, Ahmed Ali. Rahman Shah.
A week's time. Yes.
Seal number 8, Authorized bodies.
No representation for dismissal tomorrow.
What is it?
A week's time.
Please. Seal number 9, Uttar State.
Yes.
Seal number 10, under Item 9.
No representation for dismissal tomorrow.
Seal number 11, Imran Farid.
Same order.
Seal number 12, Dinesh Kulkarni.
A week's time.
Seal number 10,
Week's time again.
10. A week's time.
Please.
Yes.
Seal number 12,
Actually, I asked. Now, what is called now?
seal number 10.
No, 11 also is there. 11? 11 you didn't call.
Seal number 10 for dismissal.
No, just only mentioned, no. 1 week time.
Seal number 10.
Yes.
Please.
Seal number 12, Dinesh Kulkarni.
Week's time. Next 13.
Seal number 13, S.G. Kadkarni.
A week's time.
Seal number 14, Ashoka Kalachandni.
A week's time.
Seal number 15, Vijay Srinivas.
A week's time.
Seal number 16, Sunil S. Desai.
A week's time.
Seal number 17,
A week's time.
Abhilash.
Yes, next.
May I request 10 days?
Right?
I'm just uselessly 5 minutes.
10 days time before order. Yes, next. Next.
Non-compliance of office subsection for third time. Seal number 18, seal number 19, PSNP.
I will not press the petition. I will file a memo. I will not press the petition.
A memo is filed saying that the petitioner do not want to pursue the matter and same will be dismissed as not pressed accordingly. Petition is dismissed. Take the
Yes.
memo. Yes, next. 20.
Seal number 20, Rajshekar Puri.
A week's time. A week's time. Yes, next.
Seal number 21, Mahatesh Sirema.
Because the week's time.
All dismissed. Seal number 22, Mallikarjun Samiti.
For deletion of response number 4,
Hmm?
will be considered. Memo for deletion.
Non-filing of memo regarding LRs of R4.
I am filing a memo for deletion of the response number 4. Since there is no claim on it.
He need not be deleted. You can file a memo saying that I am not seeking any relief against respondent number 4. So notice to him may be dispensed with. He cannot be deleted from array of respondents.
Response number 3 and 6 for dispensation.
That's why file a proper memo saying that you are not seeking any relief against respondent number 4. Notice to so and so may be dispensed with. We cannot delete him from the array of respondents.
Because he has not been arrived at party in the petition also.
You have to array all the parties as per the cause title given before the court below. And after that, you have to file any memo if you don't want service to them. Do it. Office objection.
In respect of response number 3, filing a memo for dispensation. Tally procedure. I'll file
For this also file under memo.
in respect of response number 3. Notice the timely.
It is stated that a memo is filed seeking dispensation from notice to R3 at the risk of the petitioner. Notice to R3 is dispensed with. The other objection shall be complied with.
And in respect of respondent number 4, I will file it. Should we call
That's
that?
what, in respect of respondent number 4, the petitioner submits that he is not a proper and necessary party to this petition. In that regard, he shall file an appropriate memo. List this matter on Monday. Next.
Seal number 23. Otherwise,
In course of the day,
Yeah, it is submitted in the course of the day. The objections will be complied with.
in course of the day, I will pay cost owners, sir. Which time will be made for the compliance of officer?
Non-compliance of office objections is serial number 4A. Non-filing of memo, cost paid received.
In course of the day,
And for complaints of office objections, how much time?
which time will be made?
A week's time for complying with the office objections. Granted default order. Land council submits that as far as filing of the memo with regard to the cost, he'll be complying with the same during the course of the day. Yes. Next.
seal number 24. Is there anything inside? Naveen Chandra.
Payment is fair.
Hmm.
If my last submit, I will agree with it.
Yes. No, we will take up this matter. Please wait after this orders are called.
Please.
Why? At the request of land council, responded list this matter on Monday. Yes, next. It is submitted that the settlement talks fair. Yes,
Interim.
interboard order granted is extended
Obliged.
to the next date of it. Yes, next.
Seal number 25. If you would be, it was denied.
This matter, I request for the respondent. On the last occasion, my colleague made a submission that the respondent is ready to settle a matter at 15 lakhs. In fact, it was on the submission of on the instruction of the respondent only. Now the respondent is casting.
Who is respondent here?
No, I am for respondent, okay. But now the respondent is casting aspiration on me regarding that submission. Therefore, for the court.
Oh.
But may I request the court can not ask her. She is ready to settle
What aspect she is creating on you?
that she has not instructed me to settle it for 15 lakhs. That's not.
What was the order on the last
Order.
occasion? Then transfer the respondent, suppose the respondent is ready for one-side settlement of the case. She has said, that was your instructions.
That was not.
Ask her to come. Ask her to come this side. I'm not able to see her. You want to settle the matter or not? How much is the amount? And then she says the same thing.
But now that she is taking yesterday as per our.
Have you instructed him or not that you are ready for 15 lakhs? Ask her, no? Ask her. No, you ask her that whether she has instructed the advocate. क्या बोल रहा है?
कंफ्यूज कर लिया अभी 15 लाख को
उसको बोले कि नहीं बोले एडवोकेट को? तो क्यों बोल रहा है एडवोकेट को ऐसा? सब बोला नहीं चाहिए ना?
And one more submission.
She says 15 lakhs.
No, that's all. But she says that some gold is lying not with the husband. That she will not change.
What are your instructions?
I sought for the same 15 lakhs for us. That is, it would be too erroneous and settling.
For him, it will be two.
But that little higher on the tax.
Oh.
And yeah, suppose that she is ready to pay monthly maintenance instead of giving a lump sum amount. Instead of the salary itself is going to be given.
No, how much is the maintenance granted with the trial court?
20,000 has been granted.
So how much you will pay?
She is ready to pay every month 15,000 months. still,
Tell her now.
One-time settlement.
Otherwise, she will not accept, court should not pass the order. Yes, what is that? Let's see, on the merits of it, will pass the order. Yes, let's see.
yes.
Come to reasoning part.
Please. Page number 15, madam. Page number 18, madam. Start with page number 18 of the petition. Part number 12, madam.
Para number
Part
12.
number 12 of the judgment, madam.
Please read.
Please. The respondent admits his marriage relationship to the petitioner, but he denied the other allegations made by the petitioner against him in his objections to the main petition. The respondent has not laid his oral evidence and not marked any documents in support of his case. The petitioner is examined as PW1 and cross-examination by the respondent counsel, but nothing worth is elicited from PW1 to disbelieve her version proposed in her examination in chief. Further, in the cross-examination, the respondent counsel suggested PW1 deposed evidence that ಎದುರುದಾರರಿಗೆ 70,000 ಸಂಬಳ ಬರುತ್ತದೆ.
So the respondent submits that he is getting monthly salary of 70,000.
Sir, please.
So what do you say on that first?
But I submitted my notes in the last question. I have given the salary certificate. It shows that 52,000, 51,000 and odd is the salary.
51,000 and 51,000.
Please.
And the remaining thing is like a one-time bonus or something.
Please, in fact, last time.
Yes, yes.
Gross salary is, not, may I just, gross salary is 76,929. There are certain deduction towards his personal PF and all to KGID and NPS.
Something OT or something.
Yes.
Well, it is not my deduction. It's the government.
No, KGID is his deduction. NPS
So
is
after deductions, after statutory deductions,
Yes.
he's getting 51,000.
51,640.
640.
Please. Further,
Read from there, but as per the respondent,
therefore, the respondent admits that he is getting monthly salary of ₹70,000 per month. But as per the respondent, he has to look after the medical expenses of his parents. But to show the health conditions of his parents, the respondent has not produced any documentary evidence before the court. Further, the respondent himself not laid his evidence and not submitted for the cross-examination. That at present the petition is not staying with the respondent, it is a bonded duty of the respondent to look after the petitioner and to provide basic necessities like food, clothes, shelter, and medical expense to her. But the respondent has made any efforts, provisions for her livelihood. Even though the respondent has issued legal notice to the petitioner for giving divorce as per Exhibit P3, the petitioner also reflected the said notice as per Exhibit P4 and as
Yes.
per. No, merits that came to be dismissed by the virtue of merits. I couldn't prove anything. I couldn't prove that there is a ground for the divorce. Now that petition came to be dismissed.
which petition?
Whichever the petitioner, now hearing petitioner, has filed a divorce petition before the Supreme Court. It came to be dismissed. Now this is the only point.
Salary is 70,000.
No, what did she do? Against that an appeal is filed.
No,
Against that order, appeal is filed.
no.
So what does it mean? No, she filed a petition for divorce.
No,
What does,
divorce was being filed by the petitioner hearing.
your petition is dismissed.
Husband had filed it and no.
We'll grant, we'll make it 50,000.
No, sick leave, no.
Yes,
I-
agreed with orders passed. Criminal miscellaneous number 229 of 2022, dated 2nd February 2023. The wife is with, the husband is before this court. Parties are referred to as wife and husband for the sake of convenience. The wife has filed a petition seeking maintenance of an amount of rupees. How much she sought?
But she has sought for money. 50,000 per month.
She sought maintenance of an amount of rupees 50,000. It is a case of the wife that the marriage was organized on 5/5/2020. At the time of marriage, her parents are given rupees 25,000 cash as dowry and also other gold ornaments and spent huge amounts for performing the marriage. In view of the harassment by the husband, she left the matrimonial home. It is her case that he's working as PSI and he's drawing a handsome salary. The husband has an obligation to take care of the wife and which the respondent has failed to do. It is a case of the husband that he is not having the sufficient means to grant maintenance of 50,000 and he has to take care of his old age parents. The next part, the trial court, the family court, having considered the respective contentions of both the parties, had granted maintenance of an amount of rupees 20,000. While granting the said amount, the court had observed that the salary of the husband is 70,000, and the evidence on record discloses that the husband has neglected the wife and has failed to provide maintenance to her. She is entitled for the maintenance, but not to the extent of amount claimed by her, and accordingly granted an amount of rupees 20,000 as maintenance. Next part. Aggrieved thereby, the husband is before this court. Learned counsel appearing for the husband submits that the salary is the salary is 70,000, but after all the deductions, his take-home salary is 51,600, and in that he has to take care of the aged parents and has to take care of his necessities. And the court had granted substantial amount as maintenance, which is on the higher side. He submits that the petitioner, the family court, without considering the evidence on record, had granted the 20,000, considering the salary as 70,000. Next paragraph. When counsel appearing for respondent submits that the court, considering the evidence that the salary is 70,000, considering the fact that the salary is 70,000, has rightly granted the maintenance. He submits that when the matter came up on the last occasion, he submitted that the wife is interested for a one-time settlement. Today, the wife is present before the court. She submits that she is ready for a one-time settlement, and also the such a gold ornaments are lying with them. The same can be returned. Learned counsel for the husband submits that the husband cannot pay one-time settlement of 15 lakhs, and it would be comfortable for him to pay the monthly maintenance. Next for having heard the counsels on either side, there is a material on record. The whole basis for the court to grant the maintenance of 20,000 days, considering the 70,000 the salary of the petitioner. The petitioner has placed before this court the salary slip, wherein it shows that after all the statutory deductions, his take-home salary is 51,600. In that case, the wife is not the maintenance that is granted at 20,000 is on the higher side, considering the respective arguments of both the parties and the salary of the petitioner. This court is passing the following order. The order of the family court is modified, and the maintenance amount of 20,000 is reduced to 15,000. Accordingly, the petition is partly allowed. Next.
Number 26. Relation.
Weeks accommodation mechanically granted knowledge. Weeks accommodation mechanically granted knowledge.
The notice to respondent number 1 returned as complaint amount stream service of notice. This is matter for admission tomorrow.
Respondent number 2 is realized as duties.
This is
R1 deemed service. Then council submits that for taking steps in respect of deceased R2 seeks a week's time. It says default order a week's time. Yes.
Number 27. South.
Lords,
Yes.
I request your lordship kindly have it in the month of December, my lords.
Why?
Lords, I'm not keeping well, my lords. Therefore, my lords.
No. Simple the order. Why you want? It's on the maintainability. What is the order?
Yes, my lords. My lords.
It's office of
Sub party.
Yes, my lords. Yes, sir. Am I audible?
Audible.
Yes. This is here.
Please, sir.
This is here.
127. 125.
सामने कोट का ही है ना और सामने कोट का ही है The office objection with regard to the maintainability is overruled. This is matter for admission on Monday.
My lords, kindly have it on in the month of December, my lords. First week of December, my lords, due to family necessity.
This is matter on 9th December.
Grateful, my lords.
Yes. Next.
Number 28. Judicial part.
Yesterday, I took an actually with the one without informing the adversary. There was some internal miscommunication on part of this.
No, it's not a miscommunication. When the cause list shows that without mentioning, informing the other side, you cannot make a mention. That you will do. Then what is I'm not, every day I'm making it, every time I'm asking the advocate, have you informed the other side? Then you should have followed it.
Communication between the parties.
Between?
Between my parties. So we were not informed the others.
He was waiting till afternoon.
Because we are waiting cost.
Then Arju,
There's also one more connected petition that was already connected. Then we have charges to be added. My request is for tomorrow.
Tomorrow.
Still number 29. Review Pakka.
Husband's petition, ex parte have been passed by the family court.
Furnishing of so and so
No
to
such
respondent.
person has-
They could substitute service of notice.
Please.
Petition shall come up with an application to substitute the service of notice on the respondent. This is matter when?
28 months.
28.
Please.
Next.
Still number 30. Well, you
This
answer
matter
what?
was, I heard the wakalat on behalf of respondent number, but my name has not been shown in the process.
Take the name of
Please.
then counsel subsidiary has filed wakalat for the respondent. You have the papers?
Yes.
Papers you have?
No, next.
Then counsel of the petition shall serve the set of papers on the counsel for the respondent. This is matter on Saturday?
Please.
Yes.
Next.
This Saturday?
28.
On this is matter on 28.
Please.
Interim order is there? Interim order earlier granted is extended than that. Yes, next 31.
Still number 31.
Petitioner try to serve the notice on the hands to the respondent, but she is unable to serve
Because
because
the respondent is on the council.
the council also she is unable to get it because his address is shown as Bagalkot, but he is not there at Bagalkot University.
Advocate is not in Bangalore.
He is not in Bagalkot, my lord. Address is given as Bagalkot, but he is not.
The-
Fresh notice may kindly issue, emergent notice I will serve.
The registry is directed to issue emergent notice to the respondent.
Interim order.
Interim order earlier granted is extended. Yes, ma'am.
Still number 32. Petitioner.
No representative for dismissal tomorrow.
Very good. Still number 33. Then party.
No representation for dismissal tomorrow.
Still number 24. Sir Kalwa.
Notice to the respondent. Huh? How much is the delay? 54 days. Generally, the procedure which I follow is when there is a delay, will not entertain the state petition. Issue emergent notice to the respondent.
Still number 35.
My lords, for the petitioners, my lords, speaking for the recalling of the order dated 10/9/2024, my lords. It was dismissed for non-prosecution, my lords.
Serve the papers on the council appearing for the respondent.
My lords, I have served it, my lords. I have served the copy.
It's here. He says it is not served. Then a council for the petition shall serve the copy of the IA as well as the main petition on the council appearing for the respondent. This is matter on Saturday.
Obliged.
Tomorrow.
20.
Yes. Notice.
Still number 37. Absorption party.
Notice.
Still number 38. Combo case. Gita.
Sufficient evidence, there is a way of proof and contradiction.
Where is the R1 served?
Sir, Gita, or Gita.
I number 1 of 2024 is filed to condone the delay of 325 days in filing. The notice is served and the respondent no wakalat is filed for the reasons stated. The delay of 325 days in filing the petition is condoned. This is matter preliminary hearing tomorrow.
Interim order will be extended.
Interim order earlier granted is extended. This is tomorrow for hearing.
Tomorrow.
Yes.
I think the 2 weeks accommodation, my lords, in 38 matter, because they may appear, my lords.
Don't worry about the appearance. Yes.
Because if they appear, the matter will be settled, my lords. Hence I say.
Let's see. Let's see whether there is a, yes. Yes, next.
Dismissal matters. Seal number 39.
Yes. Yesterday I was in Sekala.
It's already an IUF for recalling the order. And again on that recalling the order, you will not be present here. When is the order passed and why should it be recalled?
6/9/2024.
6/9?
3/9/2024. For non-compliance officer. Only objection is the order is not certified for due to some reasons, he was not really certified copy of the order.
It is happening from 1/9/2021. We are in 2024.
Due to COVID impact, he was not really certified copy of the order. Meanwhile, the Honorable Court passed the interim order for stay the execution and operation of the MVC number, MVC case. So, now we get the certified copy of the order. So, Honorable Court recalled the order and what is that certified copy?
So, this WP of this MC of which year?
2019.
Is still pending. Stay is granted by this court. Without you filing anything.
No, the certified copy is not being certified copy. Was not certified copy.
Where is the counsel for the respondent? Let the counsel for the respondent be present. We'll see. No representation for the respondent. Tomorrow itself we'll file the, we'll pass the orders also. No representation for the respondent. This is matter tomorrow as partner. We will pass main order itself. No recalling in 2 steps. Only 1 step. Yes, next. No representation for dismissal tomorrow.
Seal number 41. 41.
Yes.
And I have tried memo of calculation. Now it is balance 1/5,000 balance sheet. They have given a 35,000 last revision. But they have mentioned the name Vidyalakshmi Parvati Purvati. That's it. I will request it to
When counsel with the respondent submits the name of the wife is mentioned as
Vidyalakshmi
instead of
Parvati. It is good name. She has 2 names. But in the account also it is.
No, just because the disputes are pending, you forgot the name of the wife also.
He has taken it in Naguru. And
Instead of her name is Parvati, and the check is in the check the name is mentioned as Vidya. The counsel respondent has returned the check, and the petitioner counsel shall place before the check for the amount of 35,000 by Tuesday. Then what about this? As per the interim order, the remaining amount is 1,05,000 arrears.
Your Honor, I am submitting my memo.
According to you, how much?
Actually, fully it is compliant, except this check, Your Honor. And as per the interim order.
How much is the order? As per the interim order, how much?
As per the interim order, 5,000
per month.
Per month.
That is from the date of petition.
From the date of petition.
When was the petition?
From the date of the order of 6/10/2023. Earlier it is 10,000. 1 year.
Whenever it is calculated, when we say pay 50%, arrears also at that amount only, not from the date of order.
I have mentioned the 10,000 from the date of it. That's why it is accordingly.
So otherwise it is, otherwise he has complied with.
Immediately.
If it is from the date of petition, then he has complied with even according to your calculation.
Yes. That's why the 50% of that amount of 1,80,000.
No, that's why we'll not look at it. When the court grants 5,000, it's 5,000 by 5th of every month, and the arrears at 5,000 from the date of petition till now. It is complied with. Okay. will you have it on Tuesday?
Please.
By Tuesday, the petition shall place before the court the check with the correct name.
Please.
Delete from the caption dismissal. Yes. 42.
BM Mulimani?
My lordship, week's accommodation may be given. I'm seeking.
Why the office objections are not complied with from 2023?
I seek 1 week's accommodation, my lord. Only 1 week. I'll comply that, and it may be taken for her hearing.
Finally, a week's time default order. Or delete from the caption for dismissal. Yes.
I'm kindly permitted to file the memo.
40.
43.
A memo is filed stating that the matter is settled between the parties and the petitioner wants to withdraw the petition accordingly.
Please.
The petition is dismissed as withdrawn. Memo is taken on record. Yes. Huh? A week's accommodation delete from the caption for dismissal. Same default order. Next.
Number 45. Aapki board pade. Aapki board pade. Number 45.
This petition is filed on 25/1/2024. The petitioner the court has raised an objection with regard to maintainability, and even till when the petition is filed in the month of January till November, they have not even clarified about the maintainability of the petition. On 21/11/2024, when the matter came up before this court, as there was no representation, the matter was directed to be listed today under caption for dismissal. Today also there is no representation. Accordingly, the petition is dismissed for non-prosecution.
Number 46. J. Shetty.
I'm appearing for the petition.
Huh?
I am appearing for the petition. Front petition.
Yes. Where is the counsel for the respondent? No, there is no representation for the respondent. Counsel for the petitioner is present. Delete from the caption dismissal and list this matter as part for tomorrow.
Number 47.
A week's time. Delete from the caption for dismissal.
Please.
Yes.
Number 48.
Since yesterday's matter, Your Worship, the morning could not appear, Your Worship.
Huh?
And in the morning, it could not appear, Your Worship.
Yes, delete from the caption 1 week's time and same default order. Yes, 49.
Yes.
Number 49.
Delete from the caption for dismissal. Huh? A week's time. Yes.
Number 50.
Same, delete from the caption for dismissal. A week's time default order. Yes, please.
Admission matters. Number 51. K. Party. Disciplinary order. K. Party. Number 51.
On 18/11/2024, when this matter came up before the court, as there was no representation, the matter was directed to be listed for dismissal on 13/11. On 13/11, the counsel for the petitioner has appeared before the court and requested to list this matter on 22/11/2024. This court made it very clear that no further adjournments will be granted, and accordingly directed the registry to delete the case from the caption for dismissal. Today, when the matter is called, there is no representation. This is matter for dismissal. On that caption, tomorrow we will hear it.
Yes.
Oh, yes. Tomorrow. Yes, it's 52.
23. Say number 52. Authorized some parents. Yes, fine.
Wait for experience.
The requested is managed. I was given to us that the children are residing with him. Only the wife has not joined him. So that to the extent of her maintenance, it may be allowed.
She cannot claim her maintenance because the conjugal rights order has
Is
attained
there?
finality. Attained finality.
When is that?
Your Lordship, the order was passed on 28/2022.
28, 2022.
Please.
One suggestion, madam. In the criminal miscellaneous, the husband has not contested the matter, though the notices were issued to.
No, we know he's here, we'll see. So 28, 2022 is the
Conjugal rights order.
restitution one.
Please.
Then when is the imprint order?
Imprint order was
11/8/2020.
passed. He was placed ex parte.
11/8,
2022, my lordship.
2022. Now, again, is that order of restitution, whether the wife has filed any appeal?
No, my lordship.
She has not filed. So when a wife without a reasonable cause is staying away from the husband, she is not entitled for maintenance. That too in the particular facts and the circumstances, where the children are also taken care of the wife, will not grant any maintenance to wife.
My lordship, he has not contested the matter at all, my lordship.
Might be, but by that time his restitution petition is pending. Had he contested, if I remand the matter, for example, if I remand the matter, what would follow? The same thing will follow. Because a restitution order is in his favor and you have without a reasonable cause, you have not joined him.
No, my lordship, there are some allegations about the husband. He has not come and.
Hey, for that, what you are supposed to do? She has to file an appeal.
My lordship, let it be true. If it is remanded because.
No, the court under this summary procedure will not go into all that because the competent court has already held that there is no reason for the wife to stay away from the husband.
There is no, she has not contested that matter and he has not contested this matter.
But that is staring at him. This too we can look at too because we can take that into consideration. She should have questioned.
Both of them are not contested in the matters filed by each other.
But that has the effect on this. The agreed by the order passed in criminal miscellaneous number 20 of 2022 dated 11th August 2022 whereby the court had granted maintenance of an amount of rupees 23,000 to the wife.
And entire 5,000 each.
No, to the wife and
Children.
how many? To the wife and 3 children, an amount of rupees 22,000.
5,000 each for the 3 children.
And 8,000.
And 8,000 for the wife.
8,000 to the wife and 5,000 to the 3 children each. It is a case of the wife that because of the harassment between the parties by the husband, she has been staying. She has come out the matrimonial home and staying along with her 3 kids, and the husband has failed to maintain her. Before the court, the husband was set ex parte, and an order is passed granting maintenance. The agreed by the husband is before this court. When counsel appearing for the husband submits that the husband had filed MC number
273 bar 2021.
273 bar 2021 seeking under section 9 of the
before the principal judge family court Ballari.
Under section 9 of the Hindu Marriage Act, seeking restitution of conjugal rights on the file of the principal family court Ballari, and that came to be decreed, and where in that case the wife was set ex parte, and it came to be decreed on 11/8/2022.
28/2022.
28, 28
month.
That's for 2022 that came to be decreed. He submits that when, in spite of an order passed by the court for restitution of conjugal rights, when the wife is not staying with the husband, and which clearly shows that without a reasonable cause, she is staying away from the matrimonial home, she is not entitled for maintenance under section 125 CRPC. He submits that.
There is a small mistake in that. In the LC petition, she had contested. She was represented by an advocate also. Kindly, page number 44 of my petition may kindly be corrected.
Yes, that you remove. That restitution she is not contested. He submits that when she is staying away from the husband without a reasonable cause, she is not entitled for maintenance. He submits that the 3 children are staying with him and he has been taking care of them. Next paragraph. Then counsel appearing for the respondent submits that when the husband has not contested the matter before the family court, he cannot come up with all these kind of submissions before this court. It is submitted that it is submitted that the matter may be demanded so that both the parties will get a reasonable opportunity to contest the matter. But however, she does not deny the fact that the children are staying along with the father. Next part. Having got the counsels on either side, there is a material on record. It is an undisputed fact that the husband was at ex parte before the trial court. The order was passed, the executed order is passed on 11/8/2022, and the decree in restitution conjugal rights is on 28/2022. 28/2022. Now, when the matter is before this court, just because the husband has not contested, even by remanding the matter to the trial court, no useful purpose would be served, as already there is a decree of restitution in favor of the husband, which is unchallenged by the wife. That itself shows that without a reasonable cause, the wife is staying away from the matrimonial home, and further, the children are residing along with the father. In such event, the maintenance that is granted to the children as they are with the father has to be set aside. And as far as the wife is concerned, as she is staying away from the matrimonial home without a reasonable cause, in the light of the judgment and decree passed in the petition filed by the husband under section 9 of the Hindu Marriage Act, the wife is not entitled for maintenance. Accordingly, the petition filed by the husband is allowed by setting aside the order dated so and so.
Number 53.
Salgon to bilingual. What is the distance?
More than 40
Huh?
More than 45 kilometers.
Which year is the MC? I think I have asked you to file the. Is it the case? Where is that? Give that.
I have produced along with memo to the statements.
You filed along with them. Where is that? You have it? You have a copy of it now? Then, without you having a copy, how will you represent?
I was actually consular on record, she is on maternity leave, she is handed over to the police.
When council submits that, when was the order of the court? I think in this it is not, there is no order. Then counsel of the petitioner shall place before this court the order sheet of the trial court. But next date of hearing list is on 28.
28.
Yes, Judge.
Number 54. B.A. Bandekar.
So we are challenging the order of the learned
family court, hearing, the Learned High Court has awarded 20,000 rupees per month for both the
Wife and daughter.
wife and daughter.
Huh?
Wife and daughter.
What is your income?
I am not doing any work, and according to the owner, he is assisting his father who is a businessman, and they are doing a kirana shop in Athens.
You have contested the matter?
Pardon?
You have contested the matter?
Yes, I have contested.
Both of you have filed your statement of assets and liabilities?
Yes.
Please come to the order, let us see.
And in my objection in the right court, I'm kindly consider the fiction.
So let's see the reasoning of the court, then we will go to the other documents. Please come to the order, impugned order.
And right from the very beginning, madam, we have contended that the wife is not entitled because she is also earning. She is a become graduate and doing even MBA also. And she is working in a reputed institution in Dublin, in JSS College, Minneapolis College at Udal. And all these matters, and right from the very beginning, we are ready to take her back. And we are ready to pay maintenance, even we are not neglected. And all these facts we have, in the cross examination, it has been admitted. Therefore, even now also, I am ready to take her back. And I want to respond, the petitioner is also present. He wants to take back her, and he wants to make separate arrangement either in Athani native place or Belgium or in Hubli or wherever she wants.
Yes.
Firstly, madam, she is not ready why? Because 498 is pending and everything is also admitted by them and there are proofs for 498A. I will show to the honorable court also. And second thing, it is admitted that she is working as a teacher, that is LKG UKG teacher.
How much is earning?
10,000 per month. And that is admitted in the cross examination also. Until today, she admits that she is working.
What is the income of the husband?
And he has some distribution ship managers.
No. What is the evidence on record?
On record, that is, they have produced some distribution agencies, and he accepts that 8 to 10 lakhs. 8 to 10 lakhs. In this cross examination minutes, he has accepted.
How much is the income?
$8 to 10 lakhs he has admitted.
Per annum?
Per annum.
So how much per month?
And even he is having some agriculture lands.
How much per month?
More than that also there are some other businesses also. Only in his name this business is registered.
But we can only look at, understand what is his income from the statement of assessor liabilities or any other document you file.
He said that was in the year of 2018 and 19, but now it might have increased.
Let us take it like that. So, if he is having per annum.
Sorry, Manoj, sorry. That is 15 to 20 lakhs turnover. In the cross examination, he has accepted. He has accepted, Manoj. We can suggest many things, but as he has accepted, it is his part. And the GST forms also, they show that turnover like 50 lakh to 1 crore, which is produced before the trial court also. They have not disputed that. He has many sources of income. Just because she is earning, she is not capable of it. She is not.
Fine. So, for example, his monthly income is it would come to how much per month?
If at all we take 15 lakhs also per annum, it comes to 1,25,000 per month. Per annum, if at all he earns 15 lakh per annum.
Is it so?
Let them produce their IT returns, Manoj. If it is false, let them produce.
All the IT returns before the
present this year, last year, let them produce. If at all it is
counsel for the petition is directed to place before this court the income tax returns for the year 2022-23 and 2023-24.
Please,
This is marker on 28.
please.
28.
Yes.
May I request it on December 3rd or 4th, my lords?
This is marker on 10th of December.
Obviously. Obviously.
Number 55. We are saying open.
Please, my lords. Vice petition, my lords. Initially, the petitioner wife filed a maintenance petition before civil court, my lords. The civil court awarded 1,000 to the petitioner wife, my lords. The respondent has gone challenge to the said order before family court, my lords. The family court allowed the petition.
See the equivalent.
Please. At page number 12, my lords, annexure A is the interim order, my lords.
The court has set aside that order.
Please. Only on the ground that the name, only the name of the respondent husband is appearing on the basis of the, that reason it has set
The
aside-
relationship is not established.
Established, my lord.
Then
In
what?
Aadhaar card, in OT.
Let's come to the reasoning part.
Please. My lord, at page number 26, paragraph number 23, my lord. May I read?
Please read.
But in this case, the petitioner she has produced the original transfer certificate of her daughter Manjula under Exhibit P5, wherein the date of birth said is Manjula is clearly mentioned as 15/7/1983. The petitioner during her cross-examination, she clearly admitted that now her age as 15/2017 on the date of evidence is 52 years. If that is taken into consideration, then she might have born in the year 1965. Further, the petitioner has produced her Aadhaar card under Exhibit P2, wherein her year of birth is mentioned as 1966. In Exhibit P2, the husband name is only shown as Ashok. It is very relevant fact that the petitioner she has produced the original election identity card under Exhibit P3, wherein as on 1/1/1994 her age is shown as 29 years and the place of her residence is shown as house number 139/7, Taurgera, and in Exhibit P2, Aadhaar card, her house number shown as 189/7, Rajputoni, Taurgera. Further, the petitioner, she has produced family health awareness visiting card under Exhibit P4, wherein only the name of one Ashok is mentioned as head of the family. Who is that Ashok? There is no evidence on the petitioner. In Exhibit P5, original transfer certificate of one Manjula, wherein the name of the father is shown as one Ashok Udaynur Hotel, and the name of the mother is shown as blank. So the name of the petitioner is not at all mentioned as she is the mother of the said.
Please come. Notice for respondents. Yes.
Number 27. Murad. Yes, Mr. Dharwad.
Are there for respondent? Why?
This is, I have challenged this annexure here, but annexure here, maintenance is granted 8,000.
8,000 to the wife.
To the wife.
What is the income of the husband?
Income of the husband as admitted by the respondent herself, it is 42,000. 42,000. I don't say that this is excessive or other. The respondent is, the petitioner is working in as a SPC in Chitkote. The thing is, marriage has not been continued. So, hardly after 1 week, the wife left. On the ground that the petitioner is having old mother and she is staying in Bijapur. And Chitkote and Bijapur is about 60 or 70 kilometers away. It is a different district and Chitpur is in Belgaum district. The thing is that she is not ready to stay with mother. So that was ignored. And she went
Any
to
petition for restitution is filed by the husband?
Husband has not filed any restitution, but the conciliation proceedings have taken place, but they have failed. And she is pursuing parallel remedies under the DV Act and here. Under the DV Act, she didn't get any relief maintenance. So 125, 8,000 award of maintenance.
Our prima facie, we have to, under 125 CRPC,
CRPC.
inquiry is very summary in nature and we don't go to.
I'm not disputing. The thing is, and even parallel proceedings can be proceeded by the parties. It is their choice. The thing is, as per the order of this honorable court, I have deposited 50% of the arrears, as well as I am paying 8,000 per month presently before this honorable court. Till date it is paid. Now the order is whether we can make any conciliation between the parties so that I will keep the parties present. So that once for all, we manage this.
We'll try.
Appear before the mediation.
Please.
Both the parties have, it is submitted that there's a likelihood of compromise. Both the parties shall appear before the mediation center on 28th.
Please.
Next week, 28th. 28th.
Meantime, let them deposit entire areas.
As per the order of the court, I think he has to for 50%.
Please. I will
And have they withdrawn?
They are not put
As as per the order passed by this court, the husband has already deposited the amount. The respondent wife is at liberty to withdraw the same.
Please.
Next.
Number 59. Salvation.
Yes. What is the revision?
Revision is against the orders passed by the trial court members. We have filed an application under 81-52
Yes.
for disobedience of permanent injunction decree, and that came to be dismissed on the ground that he could have filed the application within a short period.
So when was the violation? When was the application?
Application was filed.
Let's see the order so that all the things will be clear. Order is in Kannada.
Yeah, everything is in Kannada.
File an application. If you want translate urgency, translated translation.
Little bit urgency is there.
Then file a translated copy. We'll hear it on Monday. Monday. This is matter on Monday. By the time the constitutional.
At least 2 weeks time.
The court has no problem. This is matter on 9 December. By the time the translated copy of the order shall be filed.
Okay.
Yes.
Number 60. Shah Vasantara. Kumar.
No representation for dismissal tomorrow on behalf of both the parties. Next.
Number 61. Mr. Dharwad.
No representation for the petitioner for dismissal tomorrow.
Number 62 order. Number 63. Number 30 Saukar. Mr. Dharwad.
Respondent.
Yes.
Respondent has filed a suit for declaration. Suit order is the trial court has earlier framed the two additional issues with regard to the jurisdiction, economic jurisdiction. They are not case 28 may continue. There are two issues I will frame, two additional issues regarding court as well as the economic jurisdiction.
28.
28 is always one of the things.
The defendant proves that the court fee paid to the plaintiff is insufficient.
Not properly.
Whether the defendant proves that the court has no pecuniary
Yes,
jurisdiction.
trial court holds that one, it has no jurisdiction, it exceeds the valuation, so therefore it has been, the claim was returned. The 7 rule 10, that time was given, and represented the claim, and it is renumbered as OS 203 of 2022. After that, the representation, we have also filed the valuation memo at page 71. Where made the valuation is made. And the involvement that valuation, I have filed the application for rejection of claim. Since the not properly evaluation is filed. Trial court mode has in the represented court, that is senior chief judge. Court statement again, we recorded the finding as if appeal is filed against that order of returning the claim, and court statement it is valuation is 1 lakh. That finding may kindly be seen at page 18. Page 22 onwards. Page 22, paragraph 16. So all the judgments have been extracted and the trial court. Page 22.
Order is on IA number 2.
Yes. This is a contentious have been noted, and judgment of the one judgment is paragraph is accepted. Court findings starts from
whether the valuation made by the plaintiff is in accordance with law and court fee paid with the plaintiff is proper and correct.
Yes.
The main objection of the defendant is that plaintiff has not paid the court fee and market value as the plaintiff. What are the documents that you have placed before the court that to say that the market value is not proper?
No, but they themselves are not.
No, not they themselves. When you're they filed something, you're disputing it.
Yes.
What is the document filed by you?
No such document is.
Then just like the document you say it is not right. There should be some basis for that.
Yes, that's right, madam. Kindly see, madam, paragraph 16, that is page 22. There are
in earlier, for a moment, can you see? In earlier Maladi 1 of 2015, we filed Maladi slip issued by the Maladi sub-registrar. Value of the property is 32 lakhs 83,200.
Let us go to that order. Where that's what I'm saying. That's what Mr. Counsel, earlier order is there. He has already showed that order. In that order, court might have recorded what has he filed. Let's see that at page number 20 it starts 25. On the other hand, para 7 you read at page 30.
On the other hand, the contention of the defendant is that the plaintiff has gifted the suit property voluntarily with her own will and wish and delivered the actual possession to the defendant. As such, she is no more a owner of the property and delivered the actual possession of suit property to the defendant. Suit property has been valued under 26B is not proper. Plaintiff has
according to it is 30 lakhs.
Yes, yes.
30 lakhs as per it. Then further, where is that discussion with regard to the?
But court has recommended that finding that not page 13 also, paragraph 13.
This court is having jurisdiction up to the sub-register Belgavi, only valued at rupees 32 lakhs 83,200. Now, how much it is valued in the present suit? Then what is this? How many times you will agitate on that?
That court has got jurisdiction, but after filing the application,
No. When he files it before that first court, yes. You said the property of the property value is 30 lakhs. Court fees is so as per that court has no jurisdiction. And taking into consideration whatever your stand, court has returned the claim.
Yes.
He has presented it before the other court as per the same value. Yes. Now you say no, that's not the value, some other value. How can you say that?
No, the thing is not after the representation of the claim. Valuation may condition that I produce that valuation memo that we have.
So every time you will have new valuation.
No, because of their valuation may condition. Suit is also for page 71 may condition.
You are restored from saying that for taking such a plea.
But they have filed it not, therefore I have to.
Page number?
Page 71.
Oh, what it says? Same, suit property 32 lakhs
Hence,
83,000.
the court fee is paid on the market value of the suit property and so and so, fairness 24 B. Suit is also for leave of permanent injunction, hence the court fee is paid on 1,000 rupees as required under 27 B. But total valuation of the property is, this market value is stated, but the suit valuation is still not stated in the.
What is the suit for?
Suit for a declaration that a will, that gift is executed by the mother-in-law in favor of the daughter-in-law. I am the daughter-in-law, she is the mother-in-law. After the death of my husband, after the death of her son, she has executed the gift deed in favor of the daughter-in-law, that is in favor of my client. Now, in the instance of one of the daughter, she files a suit.
To cancel the document?
Yes.
That is not to declare, to cancel that, sir.
Yes.
Deed.
Deed. Now, in fact, I am in possession of property. It's a house property. And we are staying with our children.
No, there are two issues. One is, what is your dispute? Dispute is the market value is not correctly stated, or market value is correct, but for a declaration, so and so should be the amount. What is your case?
My contention is, after the representation of the plaintiffs, the valuation, valuation may condition. In the plaint, what is valuation fees?
How can there be a court fee of 1,000 when you're seeking a declaration that?
No, you pendented that application on 18/8/2023. Paid court fee of rupees 93,497.
I think something, somehow or the other, you want to stall the proceedings.
No, not stall the proceedings. Only similar case 43. Their valuation in the plaint. They have to seek for amendment.
First of all, we will see what is your case. So show that Order 7 Rule 11 application.
Yes. Page 63. No?
Page
63.
The plaintiff on representation of the plaintiff has not paid any court fee, which she ought to have paid before this court. Can an application be as vague as this?
Great man, but only with regard to.
He paid 90,000. He says he paid 90,000. Court has recorded that. Where is that? Then I think this revision has to be dismissed with cause for filing a revision, frivolous revision, just like that. Page number?
Para 11 manadi, include order manadi.
12, page 12.
11.
Page 12, paragraph 11.
He has paid.
I am not on that much. He has paid it. He has paid it, that's right. But in the plaintiff alternate condition, page 43.
For those kind of reasons which are curable things, can the plaintiff be rejected on that?
But my submission is, now the trial court, that is a transfer court that is subsequent to where the represented the claim, which has recorded the finding that it is the 1 lakh is the valuation is proper. That is virtually contrary to the earlier order is my submission. That is only my grievances. There are 16 conditions. And in the plaint, they have not amended the plaint. Para 43 valuation, suit is for declaration. Hence, the court fee is paid on rupees 1,000 as required in 24B. Case 43 may condition, not where it is the plaint copy. They have not amended.
The court has relied on the judgment of the apex court. The court fee has to be paid on board. What is your submission on that? Para number 17.
That's right, but I have not done that. Plaint in the plaint, they are not amended after the representation. If you are after case
We'll
43,
ask them to do it.
if they do it, well, then I don't know.
It's only like,
One more thing, Malati, one more application is pending before this trial court regarding court fee. He filed one more application under 14 rule 2, under section 11 of the Karnataka Court fee act. During pending the application, he filed application under civil rule 11.
If it is comes within jurisdiction, then court fee question comes. The case
no,
43,
it will not come within the jurisdiction of the first court. It will not come in the jurisdiction of the second court also, according to you. Is it your case?
no, because of this case 43, valuation mechanism. After representation, case 43 for a moment we lost. Plaint valuation.
We're not going to it. Please tell the court what is wrong with the observations or the discussion of the trial court with regard to the court fees. Once you say that there is nothing wrong with it, then what has to be done by the plaintiff is to just correct that portion of the valuation, nothing else in the plaintiff.
Yes, if that is done, then my application will not survive.
So what is the grave injustice that is caused to you?
No, because the valuation, ultimately this cost to the, this is the valuation to fix the jurisdiction of the trial court where it is.
So you also agree that the court has jurisdiction?
No, if it is amended, then it will come to senior civil judge where now suit is pending.
No, that is where it is pending.
It is pending, but considering this valuation, it will not be, within the jurisdiction of the.
Then it has to go to the first court.
No, either they have to amend it. If they amended it, then I would not abide application. They can't make two contentions. In the valuation, they make it less than 5 lakhs. And after representation, without amending, they can't maintain the suit.
Ultimately, what did the court say? Let's look at it. What did the
Court
court say?
judgment cannot be rejected.
Correct.
My application is rejected. If they get the plaint
Though the
amended.
plaintiff has mentioned in the valuation slip, para 17, please read.
Yes. Though the plaintiff has mentioned in the valuation slip the property valued under section 24D, the valuation has to be made on 24D only.
That is precisely your contention on the market value. Even in your petition or before this court. Look at it. And you are saying something else now before this court.
No, this market value, they have paid the court fee, they have made it, I am not done that. Without amending the plaint in the valuation.
Where did you say so?
Please?
Where did you say? Where did you say in your petition under order 7 rule 11? Where is the discussion of the court on that?
There is no.
You also not raised that question.
That is not stated.
That is not no, but what you are submitting before the court is not scope of the revision. Please
Order
come.
7 rule 11.
The present petition is, for revision petition is filed, agreed with orders passed in I number 2 in OS number 203 of 2022, dated 27th February 2024. The defendant is before this court. The respondent herein Where is your plane?
Plaintiff is 41. Prayer is 43.
Originally, the suit is filed before the principal civil judge at Belgavi, seeking a declaration that the gift deed dated 2010-2014 alleged to have been executed with the plaintiff in favor of the defendant in respect of the suit property is null and void and it's not binding upon the plaintiff, and also sought for a permanent injunction. Then in the court had framed an issue with regard to the jurisdiction, pecuniary jurisdiction, and it was held that the court is not having the jurisdiction to try the suit, and the same was returned. Thereafter, they have presented the same before the principal senior civil judge and CJM Belgavi, and it is numbered as suit is numbered as OS number 203 of 2022. In that, again, the defendant had filed the petition on order 7 to 11. You said page number? Page number.
Application 63.
Filed a petition. That the plaintiff has valued the suit, the relief of that is 1,000, as plaintiff has not made any proper amendment or filed any valuation of the suit, and the property of the market value is more than 5 lakhs. It is the case that the plaintiff has not paid any court fees, which ought to have been paid before the court, and the plaintiff is liable to be dismissed, and accordingly sought for the rejection of the claim. The court, by order impugned, has dismissed the said application filed by the defendant. While dismissing the same, the court observed that the plaintiff has mentioned in the valuation slip that property is valued under section 24B. The valuation has to be made under 24D. And in the considered opinion of the court, market value of the property is not correct, as observed by the Honorable Apex Court in Javaragoda case, and also in case of Venkatesh S. Just look at the citation outside. Wherein it is observed that the valuation is to be made as per the valuation mentioned in the instrument, and if no value is mentioned in the instrument, then valuation has to be made under section 24D of the Karnataka Fee and Suit Valuation Act. And the court come to the conclusion that the valuation made and court fee paid by the plaintiff under section 24D is proper and correct, and the plaintiff cannot be rejected, and accordingly the application is dismissed. In fact, the court has also observed that the court fee of an amount of rupees, where do you get that in the order? That and paid a court fee of 93,497. Next paragraph. Then counsel appearing for the defendant submits that he has drawn the attention of the court to the plaint and where the valuation is mentioned. He submitted that the said valuation, the plaint is not amended. As such, the court has no jurisdiction, that the proper court fee is not paid, and on that ground, the plaint has to be rejected. Then counsel for the petitioner, counsel for the respondent, plaintiff submits that he has once made an application before the court, and the same was returned. and he has presented it before the present court. He submits that he has paid the court fees and only with an as a delay tactics, the application one after the other has been paid by, is being made by the plaintiffs. Next para, this court having heard the counsels on either side, there is the material on record. This court has gone through the order passed by the court, and the court, considering all the relevant aspects, has rightly passed an order, holding that the court fee that is paid by the defendant, the plaintiff, is properly valued, and this court finds no reason to appear on a dismissed.
The lordship said,
That we will not.
no, I'm not, the lordship said judgment of the honorable apex court, but this honorable court, judgment is not, yes,
Something in the order she wrote that.
yes.
Both the judgments, the citation is right on that.
No,
Yes, I look into,
not the honorable Supreme Court.
no, I look into that.
This,
I look into that,
Please.
but correct.
Please.
Yes. Yes, next one.
With kind permission,
Uh. Huh?
I made the presentation of section 59.
Please use that mic, I'm not
Yes,
able to.
serial number 59, I made the representation and prayed for time to furnish the two
Translated
transcriptions.
properly.
And next number is of my wife, serial number 60. Due to inadvertence, I could not make submissions.
What has happened to that?
It may kindly be attended to some other day.
List this matter on 20, what is that to 60?
60.
60 lists the matter on 27.
Okay, yes, okay.
Number 64, Dinesh is there.
Yes.
Dinesh is there.
No representation for dismissal tomorrow. Next.
Number 65.
Submission for the petition. Wife's petition was on transfer of matrimonial case 9 of 24 from Shikarpura to Shikram.
What's the distance?
106 kilometers by road, it takes around 4.
And what about
one child.
which year is the MC?
2024.
Anything,
For a year.
anything is pending at the place where wife is residing?
No, she has not.
Please come. The present petition is filed, seeking transfer of
9 of 24. Next year, page 9, it's in Kannada. But please.
seeking transfer of MC number 9 of 24, pending on the file of the senior civil judge and JMSC Shikaripura to the senior civil judge court and JMSC Shigon. The facts of the case are the marriage has taken place on 29/4/2016 and they're blessed with the girl on 30/12/2019. In view of the differences between the parties, she has to come out of the matrimonial home in the month of December 2022. Thereafter, on 17/1/2024, the husband has filed MC number 9 of 2024 on the file of the JMFC Shikaripura, and notice was served on 2/3/2024. Then counsel appearing to the petition subject that the distance between both the places is about 106 kilometers. She has to take care of the church, the girl, and also she is depending. She is residing with her parents. It is difficult for her to travel on each date of hearing. No notice is served to the respondent. There is no wakalat is filed on their behalf. Next one, having heard the counsel for the petitioner, there is the material not record, considering the fact that the distance between so and so is 106 kilometers, and further considering the fact that she has a girl to take care of, and considering the inconvenience being caused to the wife, so and so is withdrawn. The court is passing the following order: so and so pending on the file of so and so is withdrawn and transferred to so and so accordingly allowed.
Number 66. Yes, also.
Your Honor, kindly pass over for 2:30.
No, pass over tomorrow.
Tomorrow.
Next.
Your Honor, one kind of, my senior is engaged in his son's marriage. Can you proceed on the first week of December? I would have not opposed for agreement.
You want, because say you can't, because idea is pending, that we can't adjust. Please make alternative arrangements tomorrow. Tomorrow.
Tomorrow. Still number 67.
At the request of landlord for the respondents. Yes,
Still number 67.
yes.
2 weeks.
Why? You have an interim order in your favor. Then
Finally, 2 weeks.
interim order is complied with.
I will comply the interim order.
It has to be complied. Whether you are complying with or not is also issue. Amount is deposited. List is matter on 9th. By the time the memo shall be filed with regard to the amount amount paid by the petitioner as per the interim order. Yes, if the amount is not paid, the interim order granted by this court stands vacated.
68. Give you Pata.
Where to where?
Raibag to Gadag, which is almost 180 kilometers.
Which year is the petition?
2024. MC number 50.
But the present petition is facing the answer of MC number 50 of 2024. Pending on the file of the senior civil judge and JMSC Raipal to the family court Kadak. The facts of the case are the marriage is organized on 96/2022. In view of the differences, the parties started living separately, and the husband has filed MC number 50 of 2024 on the file of the senior civil judge and JMSC Raipal. In that, the wife had received the notices on 16/7/2024. Then council submits that the distance between both the places is about 180 kilometers. Next, so this court has, by order dated so and so, held that the notice to the respondent is held sufficient. Considering having heard the council on Councillor Preacher Person with no record, considering the fact that the distance between both the places is so and so, and considering the convenience of the wife, so and so is withdrawn from so and so. Yes, allowed.
Number 69. Purpose urgent. Give respondents.
What's petition, going to upper, it's around 175 to 180 kilometers.
Which year is this? Which year is it?
24.
Huh?
24.
You appear? The
Formal objection.
huh? I'll record, even if you don't tell me. The present petition is filed seeking transfer of MC number 50 of 2024 from the senior civil judge and JMSC Mudor to the family judge at Bhopal. You said the distance is 100?
175 to 180.
The facts of the case are the marriage is organized on 24/5/2023 at Mudor. And the wife has filed MC number 52 of 2024 under Section 9 of the Hindu Marriage Act before the family court at Bhopal. The husband has filed MC number 50 of 2024 under seeking divorce on the file of the senior civil judge, JMSC at Mudor. Experiment calls for the petitioner submits the distance between both the places is near to 175 to 180 kilometers, and it's difficult for the wife to travel further. Already a petition filed with the wife seeking restitution of conjugal rights is pending at the file of the principal family judge at Bhopal as such a matter may be transferred. When counsel inquiring for the respondent husband submits that the wife had not made out any ground seeking transfer of the petition, he submits that Already he has filed an MC seeking divorce, which is pending on the file of the family court at Mudol and he submits that there are no reasons to transfer this petition. As per having heard the counsels on either side, there is a material on the court. The undisputed facts are that the MC filed by the wife for restitution of conjugal rights is pending on the file of the family court at Koppal, and the MC filed by the husband seeking divorce is pending at the file of Mudol court, considering the convenience of both the parties, and also both the matters are transferred to the very same court. There would not be any clash in the judgments. In that view of the matter, this court deems it appropriate to pass the following order. Accordingly, so and so is withdrawn and transferred to so and so. Yes.
Number 71.
Yes.
Vice petition is being transferred from Lakshmeshwar to Dharwad.
How much is the distance?
108 kilometers.
Which year is MC?
She has filed DVID proceeding in the year.
MC is which year?
This is 2020.
20? It is submitted that the present petition is filed seeking transfer of so and so from so and so. When comes for the petitioner submits the distance between the places is 108 kilometers. Considering the inconvenience, it is submitted that it is very difficult for the wife to travel. Considering the same, they shall be stay of all further proceedings on the file of so and so to the next date of hearing. Petition is permitted to take out notice, hand summons on the counsel appellant to the respondent before the trial court and shall file a memo to that effect by 4th of December. In addition to that, the registry shall issue a notice to the respondents. Yes, list this matter on 5th. Yes, next.
Order by number 72.
Please, for very small quantity. On that ground, only claim can't be rejected. In identical matter, this honorable court has rejected the.
Take that. Give it to him also, copy of the order.
And moreover, application filed by the defendant is belated stage, and contested the matter till 2013. Suit is 2013. Now they have filed IA for rejection of claim.
Which year is that? Which year is that application? IA is in which year?
14. 23, 2014.
Why you are saying that inordinately? How inordinately it is?
Contested the matter, my lord. Evidence has done, and now cross examination is to be pending, my lord. Now, my lord, at this point only can't reject the claim, my lord. It can be tried and decide the matter in trial court only, my lord.
What is the judgment? He is on a legal point.
Please, my lord.
That you have to address the court, not about the scope of Order 7 to 11. There are plethora of judgments on that.
Same, in this case also, my lord, this point is involved.
Where is the finding on that?
Finding is not there, my lord, but actually this point is involved.
No.
I will produce the same, my lord.
How many times the matter will be examined, Mr. Counsel? It's a legal point which you have to advance arguments. Not on our scope of Order 7 to 11. For that you don't require a judgment. It's all set in law. It's on some point, on a legal point, simple point, whether that is applicable to you or not, whether that, what is it, Bombay School of Law. Bombay School of Law, that is whether it's applicable to you or not.
Searching that, my lord, but I am unable to present, my lord. Monday, my lord, I will, on that point,
And
my lord.
please don't ask for further time.
Please.
Court can't every day hear the same matters.
Please.
Yes, this is matter on Monday finally. No further adjournments. Yes, it's 73.
Interim order granted that.
Interim order granted yesterday to them.
One more submission. My lord, my permission. Serial number 61. I was on my legs in protocol number 9. fact, I had requested my counsel for respondent to seek pass over on my behalf.
What has happened to that?
It is listed for dismissal tomorrow. There is
Visit tomorrow without dismissal.
interim order.
Intermode order granted is extended. Yes, sir.
Number 17.
Yes, my lords. After the respondent, husband's petition to the husband. Husband's petition, my lords.
What is this criminal petition?
My lords, criminal petition is she has filed a domestic violence case, my lords. She had made an application before the trial court, my lords. And challenging that, we had in criminal miscellaneous 17/2020 filed by the respondent, my lords, where she gets in sum of 8,000 rupees per month as an allowance for the maintenance. And we challenge it in RM, my lords, in criminal appeal 89/2020, my lords, where it was reduced down to 5,000, my lords, which she has not challenged. And the same.
So now under the DV Act, she is getting 5,000.
5,000, please, ma'am.
Then
And the matter has been stayed, my lords. My lords,
why it should be stayed?
my lords, there is no income of petitioner at all, my lords.
Oh, that's the one ground.
Please, my lords.
That's the only ground.
Please. And
Then what about the family court? What the family court did?
my lord, the respondent filed criminal miscellaneous 128/2020 for the maintenance, my lord. And she gets an maintenance of 8,000 per month, my lord.
So put together now she is having 30,000.
Please, my lord.
And according to you, you don't have any income.
No, my lord. And
Now let's see the order passed by the family court first.
please. No, my lord, my permit, sir, amendment. In the DB Act, what they have challenged the entire proceeding initiated under section 12 of the DB Act, they have challenged before this honorable court in the criminal petition, not just the maintenance. Prayer says, my lord,
That's why I asked him.
at the same time, she has not challenged the same said amount, my lord.
Let's forget about it. On what ground you are before this court?
Please.
In criminal petition, what is that you are seeking? What is the prayer?
Pardon?
In criminal petition, what is the prayer? Set aside the judgment and order. That's it. That 5,000 maintenance is questioned here.
Please, my lord. Whereas the proceeding in criminal measure 17/2020 pending before the court.
I am looking at the prayer. No. How will they ask in RPFC is set aside.
Yes, RPFC is set aside.
Then give that next criminal petition.
Criminal petition page number 9. There is a prayer. We have challenged the criminal miscellaneous 17/2020.
Is this filed under 482?
Please,
Is this filed under 482? Criminal petition.
please,
Why it should be quashed?
my lords, in the entire.
Whether a 482 petition is maintainable.
My lords, I'm making a point, my lords. I'll continue
No,
with the
first
question.
of all, with regard to the maintainability of a petition under 482.
Please. My lords, regarding the maintainability, my lords, where she has not made a single averment regarding where there has been done of physical harm or any mental torture.
That I understand.
Please.
The only query of the court is, can you file a petition under 482 to quash the domestic violence, the proceedings initiated under the Domestic Violence Act? Please look at the legal question of that.
Please.
Yes. Well,
My lords, regarding RPFC, the matter
I
is.
think it has to go together.
Please.
It has to go together. It has to go together.
My lords, for now, it may be taken, RPFC may be considered right now, because the matter is on 27. But I submit that, my lords, the coordinate point of this honorable court, I will submit judgment later, and that court it is also maintainable. The question was that, my lords, since we consider the DP Act proceeding as civil in nature, so there was a dispute, my lords, whether 226 is maintainable or 482 against the proceeding of DP Act. So, the completely based matter, my lords, I will submit judgment later, I will not write it now. So, justice, held that manner, the authority to petition is also maintainable. It's a maintainable. But whether their ground.
No, please raise the judgment, because I don't remember right now, but there is some, because there are judgments in the Supreme Court also on that aspect.
Please,
Get those judgments. Tomorrow?
Monday.
Tuesday? Tuesday?
The trial court matter is on 27th.
27th, yes, it's coming up before, no? It is coming up on Monday, 25th.
Please.
25th, not 26th, 25th. Monday. Yes.
Number 74.
Petitioner, my lord, Mary is not well, my lord. I seek on Monday, my lord.
Monday it is submitted at the learned council and the counsel for the petitioner is unwell.
Please.
Yes, no representation for the respondents.
Please.
Yes.
Preliminary recruitment is number 75. Arrangement.
Non-filing of affidavit as per. Where is the government feeder? Where are they? They're supposed to be here. As per the order passed by this board, then counsel the petitioners filed the affidavit, no representation for the government feeder, government advocate. This is matter tomorrow as part of.
No, may I request on Monday, since I have some personal inconvenience, may I request on Monday also?
Tuesday, both the next part also same.
No, only one.
Tuesday.
And the interim order can be extended.
Interim order grant is extended in the, this 76.
Number 76. Number Pacham.
Yes.
Something of the mother and son filed petition before the family court.
How much is granted?
That's main petition is pending, not implementation of rupees 6,000 has been awarded, 4,000 to the wife and 2,000 to the son. That's in order to record the said proceedings, not the petitioner's file, recovery proceedings. In the recovery proceedings, not the respondent can file calculation memo. That such amount is paid, we have also filed calculation memo. On the calculation memo, not the interim order will pass. What is the interim order not? Since the husband has made serious allegation of adulterous life against him or the wife, therefore, till the disposal of the main petition, the recovery as against the wife is kept in abeyance, only son is entitled. That order, it is very serious. I have established.
No.
I have established.
It might be, court cannot pass state's own order.
Within 5 months, I have established the adultery order.
Not adultery. Please understand 1 minute. I'm not saying you to establish adultery here. I am saying when an order is passed by the court, and that too under 125 CRPC, it cannot stay its own order. First point is that.
Only 2 months I will establish the court. 2 months.
On what point?
Well, I want to take 5 minutes time. It is serious issue.
On the legality.
What I am doing the pendency of the proceedings, she become pregnant. She has removed the fetus from the hospital. I
understand all that. Can the court do it? When the court do it is a question. For everything there is a procedure.
I agree.
No, if you have anything, you come before the appropriate court questioning that order.
Well, only 5 minutes time the court can pass the order. Only 5 minutes time. I want to convince the court. It is serious issue. When his husband has established the adultery, she become pregnant in the pendency of the.
I am accepting that statement of yours. You don't have to prove that.
I have established before the court itself.
That's what I'm saying, Mr. Constable. Please understand what the court is saying.
Please.
We'll accept everything.
Please.
That she has committed adultery. She did that. She did this.
Yes, sir.
Is it permissible for the court to pass an order?
After establishing adultery, I filed 127 application in the very same case, madam. After this case, in the very same case, court, madam, what held that it is kept in abeyance till disposal of the case, along with the main case, it will be disposed of.
What is the present? He said he filed a recovery proceedings. In the recovery proceedings, this order is passed. Can the court pass in the recovery proceedings?
For a moment, only 5 minutes. I may tell it permitted. It is serious issue. Up to Supreme Court is failed matter. Now I want to take that as in respect of that. Well, I am producing some documents along with.
Not the documents. We look at the order first.
Well, for a moment, it is very serious issue. That's why I request it.
I think You're not understanding.
I understand.
I'm saying let's look at the order, however serious, we will not look in a revision.
Please, for
Come to the review order.
Page 114.
Ah.
Order on the memo of calculation, page 114. May I read it?
Yes.
The respondent had filed a memo of calculation stating that he has paid till date around 91,000 for the maintenance of the second petitioner, and till September 2021 he had to pay 90,000. Together for all the 45 months, but because he has paid 91,000, there is a 1% excess paid, and therefore he claims that his memo of calculation should be accepted for the case. To the contrary, counsel for the petitioner has filed a counter to the calculation of memo of the respondent and claimed that total claim is 3,42,000 till date for the petition number 192, and totally 87,000 has been paid till date, and therefore there is still huge balance to be paid by the respondent. Hence, he paid to reject the memo of calculation filed to the respondent before this court. As the main petition in criminal misdemeanors number 304 of 2017 is pending, and also the cancellation of interim maintenance order sought by the respondent is against to be decided on the merits of the case. This court is of the opinion that the interim maintenance granted to the first petitioner can be recalled after criminal misdemeanors number 304 of 17 is disposed of on merits. If at all the response asserts that she is having illicit connection, the first petitioner would not be entitled for any maintenance, and hence the question of interim maintenance would also not arise. Therefore, without giving any finding on the serious disputed questions raised by the respondent regarding the alleged illicit connection of the first petitioner, this court cannot direct the respondent to make payment of the interim maintenance to the first petitioner. Remaining is also.
What is this order of the court?
For movement, how I have established the adult in my kindly. For movement, only 2 months I have not taken much time over. Whatever order can be passed, I may kindly permitted, my lord. It is very serious issue. Please, ma'am. 2 minutes I have not taken much time, my lord. Please, ma'am. For 2 minutes I may kindly.
First of all, you have to listen to the court.
Please.
Then the court will listen.
Please.
Listen to your argument.
Please.
Now, court can look into the order passed by the court, and looking at the order, court will decide what is the legality or otherwise of it. And when what order you are submitting is not part of the order.
Please.
If it is not part of the order, why should I look at all those pages?
Please. What happened, madam? In the very same court, madam, there are 5 petitions are pending, madam.
Where is this?
That's why I am taking attention.
Where is here? You cannot supplement the order.
I am not taking supplement, madam. I am not saying in the same petition, in main petition, I have established the adult, madam.
Then there should be a reason in this order.
What? That's why I requesting the honorable.
Your court cannot, please understand, you know the legal format, what is how it should be.
What
No, I can only look at this order, not what you are submitting to me.
Madam, what happened, madam? Very same court has recorded the evidence.
If the court has to record the reasons, where are the
in
reasons?
respect of that, madam, the court has not recorded, madam. But anyway, the court find that when the husband.
Where it has found, please tell the court from this order.
But after observation 127 application, my lord.
That is relevant for the court. Now, what is impugned before this court is this. In this, there is absolutely no discussion about anything.
When 127 petition is kept in abeyance, my lord, when I have established the adultery, she cannot recover, my lord. I have established the adultery, my lord, even I have to pay the maintenance to wife.
Where is this in this?
For movement, my lord. That's why I am requesting, my lord. Let the court can consider or not.
I cannot consider that. Please understand. No, I will not look at anything except this. From this, you please demonstrate before the court that what is the reason.
In the order, in this order, my lord, the court has not observed in this.
That is what he has questioned.
Yes, I agree.
So we will look at
but
this.
this court is having ample power in 227.
No, will not have. The court will not have ample power in 227.
Approach up to Supreme Court has stated
Let
that.
the Supreme Court do anything. But we can only do what we are supposed to do.
Matter is seen before the Supreme Court. That's why I want to take
What
that. Well, that's why. Only 2 minutes. Well, I have submitted some document. May kindly look at it for a moment. First document, my lord. Please, ma'am. Only 2 minutes I want to take the time.
Yes.
Please. The husband has filed the MC petition on the ground of adultery.
Yes.
Well, page number 3 of the page number.
Not on the ground of adultery, on the ground of desertion.
No.
Subsequently,
No.
Initially, only on the desertion.
Also, already he is complicating the issue. You don't complicate it. Yes.
Please.
Yes.
19, page number 19.
Yes.
Who is the adulterer? He has filed the objection before the trial court in the year 2019 itself.
Yes.
Para number 3 of the objection petition. The respondent number 1 is close friends with the respondent number 2, and respondent number 1 has not at all disclosed about the relationship with the petitioner. And also in the respect of his side, his concern, and hence this respondent has developed the relationship with the respondent. number. So further, I want to take the rest of the book. But meantime, he knew of the page number 22.
Yes.
I have called for the documents from the hospital, Ramanagoda Hospital. So in the Ramanagoda Hospital, the doctor has appeared and submitted. Lastly, I want to take the attention to page number 45. Baby is page number 45. Baby is 23 with 2 days.
Yes. Yes.
Next one. Meanwhile, this the doctor evidence are challenged by the other side before this court. So that has page number 58. So this court holds that it is privileged communication between the doctor and the patient.
Oh, please understand.
I agree for a moment, please. This order has been stayed by the Supreme Court.
Let it be.
That's why I want to take that.
Let it be stayed by the Supreme Court.
Please.
No, there is an order of maintenance in our favor. Please understand and follow. Then only you will understand what the court is asking. Because you are in an anxiety to tell the court something without listening to the court.
Please.
What I am saying is there is an order of maintenance that is granted to her.
Please.
That is not stayed. What are you supposed to do?
I have filed 120. That's why after establishing the right, I have filed 127 application for modification of the order.
Where is that order?
Please.
And in the recovery proceedings, court can't pass this kind of an order.
What happened, I have taken specific content in the recovery petition that only the child can recover the amount of because in lieu of the passing of the order in main petition 304 in respect of pending safety 127.
So where it should be passed?
That has not been observed. That has been observed.
Can it be passed in recovery proceedings without any discussion? There is every procedure for doing the right or for any great, the purpose to be achieved. But court cannot do like how the court want to do or want it to happen.
When my 127 proceedings I have initiated in the same way, conduct the inquiry, court feels that at the time of passing of the anyhow the flag end of the proceedings, that's why the court has held that at the time of passing of the final.
This order I am going to set aside. This order has to be set aside.
What happened? Page number 1. After disposal of 1.5 months, this is the interim order, after disposal of 1.5 years, they have challenged the order. The petition itself is in circulation. Main petition has been disposed of. May I take attention? Page number 18.
Which petition is disposed?
73, which is the interim order has been passed. That is satisfied. They have mentioned page number 18.
Page number
18 of the main petition. Main petition of the petitioner.
What is disposed?
The entire petition is disposed, recovery petition is disposed, that is interim order has been passed. If they want to challenge, there will be pending proceedings, they want to challenge. Main petition itself is disposed. There after lapse of 1 and 9 months, they have challenged this order.
I'm not able to understand what you are submitting.
Page number 18, madam.
What is this?
Page number 18, last month. Dated 30/11/2021. Counsel for the petitioner present and filed a memo. This petition may be closed as maintenance amount towards the petition number 2 is fully satisfied.
When is this? What is the date? That is, this is 30/11/2021. When is this impugned order?
Prior to that,
29/10/21.
29?
29/10/2021.
Then what remains to be decided in this?
they will challenge in the 2023 month.
It will come in my note, again not I will.
And what is this memo, Mr. Counsel? Please come to what is referring to.
Please, ma'am.
Please come to page number 18 of what you have filed.
Please, ma'am.
What is it? Read it at the bottom of the page.
Please, ma'am. In so far the petition number 2, ma'am. What is stated that petition number 2 is not as per the note, not he has complained. But in so far the petition number 1, why is not? The record questions have been
Yes.
there not.
Yes.
Therefore, not unless this order not such as not, I have now any option to not to record this order will come in my
The
name.
entire petition has been closed. After closure of petition, 1 and
Where do you find the entire petition?
Entire order, only
it has been closed, madam. Entire petition, even they have not.
This is set aside. This is set aside. It will open.
It petition itself is in procedural. It is interim order, my lord. Whatever order, even if it is illegal, whatever order has been passed, my lord, it is interim order.
Correct.
During
This
the
order is
pendency-
illegal.
I agree. During the pendency, the proceedings after FIR, they have to appeal, my lord. No appeal is maintainable. That is my submission. It is not maintainable.
She has passed an interim order, it has kept it in abeyance.
Main petition is disposed, my lord.
Which main petition?
73/21.
What is 73/21?
It is recovery petition, which is imputed on a challenge in memo, my lord.
So difficult to follow you. It's very difficult to follow you. 73, court has kept that order in abeyance. Does it amount to closing of 73?
No. After some days, my lord, they have filed a memo stating that
As far as respondent number 2 is concerned,
therefore, the petition, entire petition has been closed, my lord. Till this date, petition is not pending before the trial court, my lord.
then what will happen to the order according to you?
See, they have to prefer the appeal, my lord. That's my thing.
No, that also an answer. Next. Please come.
My lord, may I request, my lord, please remind, my lord, conduct the inquiry, my lord, please, by giving.
That you should have understood before making all these submissions and taking court's time.
Please, I want to draw to the notice of the court in this.
No, please understand, advocate cannot be behave like a client.
I agree. But
I can understand your client has anxiety. You shouldn't have the anxiety.
I'm not having one, but I want to draw to the.
You should tell the court when the court is asking you a legal question. And you're just behaving like a client.
No.
And this also,
Sorry, ma'am.
not to make any interim order is granted, saying him by giving reasons not for.
No, it has to be stated. What is this order?
In spite of that, they not be not getting anything. No.
No, when an order is passed granting maintenance, are you not supposed to question that order saying that because she is living in adultery, she is not entitled for maintenance? Have you questioned it?
At that time, I have not established the adult.
At that time, it is not there. No, subsequent events that have taken place.
127 application.
Then
Modification application.
order should be passed in that, not in this. Order should be passed in that proceedings, not here.
No, main petition itself I have challenged, madam, but that is kept in abeyance, madam. 127, madam. After passing of the detailed law, madam.
That's what, unless and until you have an order in 127, this order cannot be passed.
On that basis,
That is an illegal order. That is a simple thing I am trying to tell you right from beginning. Court will know, I can appreciate 101 facts, but there is a scope of every petition. You can't go beyond that.
Go through the argument, the court has not observed all these things, madam.
Then that you should have told the court. IA number.
At least I seek the remand, that's why I want to submit it.
Even if a remand also, court cannot do anything in this.
Please, please, no.
You please agitate your rights under a 127 petition.
But it has been kept in abeyance, madam.
Then you ask the court, then that order you question. Why it is kept in abeyance?
They are also not questioned, my lord. In that order, they have observed that, my lord, he has established the adultery. That's why, along with the main petition, we have disposed the matter, my lord. When establishing the adultery, my lord, it's very difficult to husband to pay the maintenance. That is my submission before.
No.
That is submission. At least the husband may kindly be permitted to establish by reopening the 127 proceedings. That is my.
I will pass such an order in his petition.
Please liberty, my lord. If at all it is continuing.
Can a liberty be given to you in his petition?
My lord, you know the court are observed in this.
I think I have given you enough time, Mr. Counsel. I cannot bear this anymore. Agreed with the orders passed on a memo of calculation filed by the respondent, dated 29/10/2021. The wife is before this court. The court has passed an order granting maintenance to both the wife and the daughter at 4,000 and 2,000. 4,000 and 2,000, total 6,000. When the husband has failed to pay the money, recovery proceedings were initiated by the wife. In that, the court has passed a simple order stating it as a orders on memo of calculation filed by the respondent, wherein the court had discussed about the contentions with regard to the calculation. The court observes that as the main petition criminal miscellaneous number 304 of 17 is pending, and also the cancellation of interim maintenance order sought by the respondent is kept in abeyance to be decided on the merits of the case. The court is of the opinion that the interim maintenance granted to the first petitioner can be recovered after criminal miscellaneous number 304 of 17 is disposed of on merits. If at all the respondent establishes that she is having illicit connection, the first petitioner would not be entitled for any maintenance. Hence, a question of interim maintenance would also not arise. Therefore, without giving a finding on the serious disputed questions raised by the respondent regarding the alleged illicit connection of the first petitioner, the court cannot direct the respondent to make payment of the interim maintenance to the first petitioner, and accordingly, as far as the daughter is concerned, the son is concerned, the court passed an order. The total payment made till date is rupees 87,000. There is a balance of 5,000 to be paid by the father for the maintenance of the second petitioner till the month of September 2021. Accordingly, he is at liberty to require the interim maintenance of rupees 5,000 for the second petitioner. The recovery of the interim maintenance to the first petitioner is kept pending till the final decision of criminal miscellaneous number 304 of 2017. The counsel appearing for the petitioner submits that the order passed by the court is bereft of reasons, and when the recovery proceedings are initiated, the court cannot pass such an order in the said proceedings. Next paragraph. When counsel appearing for the respondent's husband submits that the husband has placed the material before the court with regard to that the wife is living in adultery, and the same is pending consideration before the court. In the light of the serious allegations leveled by the husband, the wife is not entitled for any maintenance, and the court had rightly had kept the same in abeyance. Next paragraph. Having got the counsels on either side, there is a material on record. The court had granted maintenance to the wife, and in that regard, the recovery proceedings are initiated. For whatsoever reason, the order that is passed by the court granting maintenance to the wife is not stayed in any of the proceedings. When the husband has filed a petition under 127, and the court feels that there has to be an interim order, or for whatever reasons, those cases the court has to pass appropriate orders in the said petition. In this case, without any reason, without any finding, court just like that kept the recovery proceedings in abeyance, which cannot be sustained. The husband, the husband has never questioned the proceedings where the maintenance is granted, that the wife is not entitled because she is living in adultery. The court in a recovery proceedings without any basis cannot keep the order of recovery, cannot keep the recovery proceedings in abeyance without a valid reason. In that view of the matter, the order impugnated so and so is set aside. And the respondent husband is at liberty to avail appropriate remedies available to him. Yes, next.
And ladies and number 17,
User.
I have got a
Translated copy.
translated copy of the statement.
What is this CRPS arising out of?
Arising out of the interim order passed by the trial court on item number 3, wherein the application filed for rejection of the claim is dismissed.
What is the suit for?
Suit filed by the plaintiff before the trial court is one for specific performance of agreement of sale. And that agreement of sale is dated 2/11/2019. 2019 months.
2/11/2019 is the agreement.
Agreement of sale.
2019
For 2019, my lord.
is the agreement.
Yes, sir. Suit came to be filed on 5/6/1999. And there is a abnormal, inordinate, unnecessary delay of 20 years.
On that you have filed this rejection of claim.
Yes, my lord, I have filed I, my lord.
Give that memo,
Please.
translated copy. Yes. Let's see the plaint, what is it saying?
In the place, my lord, nowhere they have explained how it is.
Let's read the plaint.
Please, sir. Wait. Yes, sir. Wait, sir. They have described in the second para, the subject matter of the suit property matter. Thereafter, in para number 3 of the plaint, they have stated on 5/6/1999, the defendant about to sell the suit property in order to meet out their legal and pending necessities and to discharge their debts. The plaintiff offered to purchase the suit property for a sum of ₹1,82,000 and the defendant, though the sale price to be fair and competitive price for the land agreed to be sold and accepted the offer of the plaintiff. On the same day, the defendant received earnest advance amount of ₹1,72,701 from the plaintiff in the presence of the witnesses and executed an agreement of sale, and on that day itself, the defendant has delivered the physical possession of the suit property in the defendant. This delivery of possession will not arise upon it is their contention. And the balance of consideration of ₹10,000 was agreed to be paid by the plaintiff to the defendant at the time of registration of the deed. Thereafter, the plaintiff approached the defendant on several occasions and requested them to accept the balance of consideration and to execute the registered sale deed in favor of the plaintiff. However, the defendant went on postponing the execution of the sale deed on the ground that the name of the government has been entered in the filing of the said land, and after getting such entry removed from the filing, they would execute the sale deed in favor of the plaintiff, and on such a protest, the defendant went on postponing the execution of the sale deed in favor of the defendant. When the things stood so, the plaintiff came to know that with the ulterior motive and interest to defeat the claim of the plaintiff for the suit property, the defendants are trying to eliminate the suit property in favor of some third party.
Please come to the include order now.
He is an annexure email.
Yes.
Annexure email. It is an external page number 42 minor. The applicant is an
Please read from para number 10. I think it can be from 11.
Yes, sir. As per the clear governments of the trade, the director agreed to sell the scheduled property in favor and they have executed the agreement on 5/6/1999. This is not denied and disputed agreement that is way back on 5/6/1999. And they received ₹1,72,701 and remaining sales amount of ₹10,000 was agreed to be received at the time of execution of the sale deed, and thereafter the plaintiff was requested the defendant to execute the sale deed, and as such the defendants have assured the plaintiff that they will execute the sale deed in respect of the social property soon after the defendant soon after deletion of name of the government found in the RTC, and subsequently the plaintiff have again approved the defendant requested them to execute the sale deed, and the defendants have advised the plaintiff to hand over the position of the suit schedule, and thereafter they will execute the sale deed after rectifying the mistake found in the RTC. It is thereafter governments complained that in the month of April 2017, the plaintiff have handed over the portion of the suit schedule property in favor of the defendant.
So, according to him, he has been pursuing the same with the defendants, and you have refused. There was. He says that the intervention of the editors was also there. There are so many things. Now, this aspect of limitation under these facts and circumstances is a question of law and fact. Unless and until evidence is adduced, we cannot say.
Mere plain reading.
No, that I cannot, plain reading according to you.
Meaningful reading of the same does not disclose how this would file before the trial court is maintained. They would have stated, if there is an amendment in the claim, I will not have filed such an IA, because the parties are bound by the treaty, parties are not expected to travel beyond the treaty. Any amount of progress without treaty is also not admissible. The whole of treaty is bound by the CPC. CPC deals with the procedure. Nothing has been stated. Read in the rights in the trade government.
According to him, he says that he has been in possession of the property right from that day. That will be decided by the court whether acted upon or not, and all those things. At the threshold, we cannot.
If you have stated in this case law, then it will be different. Now, whole law is known by the CPC and these regulates.
He has stated that he has been approaching, he has been doing that and this. Now that he will establish before the court in the trial. Is it not?
Way back in the year 1977, Supreme Court,
No, it is always the court says that when there is no limitation or when there is no time for performance of the contract is mentioned, still it has to be looked at a reasonable time.
Yes.
Those are all on the merits of the matter, not at Order 7 Rule 11 stage.
Yes.
No, you might be having a very good case on the merits of it, but not at the threshold. 3 years. No, there are lines, there are judgments to that, and in respect of the immovable property, time is like always, it's not the essence of the contract. That's why I'm saying that. I'm saying you have a good case on merits, but not at Order 7 Rule 11 stage. That is not the part of this application. That you raise independently. As far as this is concerned, we'll dismiss this petition. Please come. That's the ground. The ground on which you sought rejection is only on the ground of limitation, not on the court fees. If it is open to you, you question it. If they have not paid, the court will deal with it independently. The application is the present revision is filed, agreed with the orders passed in I number 3, invoice number 187 of 2019, dated 19 January 2022, whereby the court had dismissed an application filed by the defendant on Order 7 Rule 11. The respondent herein had filed a suit seeking specific performance of an agreement dated 2/5/6/1999. It is the case of the plaintiff that the plaintiff is a case of the plaintiff that the plaintiff and the defendant have entered into an agreement for the sale of the suit scheduled property property and property on 5/6/1999. The defendant offered to sell the property in order to meet their legal and family necessities. He had offered to purchase the property for the sum of ₹1,82,000. On the same day, the defendant has received the advance amount of ₹1,72,701 from the plaintiffs in the presence of witnesses and has executed an agreement of sale. And on the same day, the plaintiff has been put in possession of the property. The balance sale consideration of ₹10,000 was agreed to be paid by the plaintiff to the defendants at the time of registration of the sale deed. It is the case of the plaintiff that thereafter they have approached the defendants on several occasions to execute the sale deed, and they have also issued a notice on 5/6/1999. And as there was no response from the defendant, he was made to file this suit. Next para. Then the defendant has come up with the application Order 7 Rule 11, stating that the suit is barred by limitation. And as per Article 54 of the Limitation Act, the limitation is 3 years. And right from 1999 till now, what the defendant is doing, there is no explanation. It is submitted that the parties are governed by the pleadings. There is no pleading with regard to the delay. and the suit is barred by limitation. This aspect was not the barred by limitation. The trial court, by order imposed, had underlying on several judgments of the apex court. Several judgments, not apex court, several judgments, has come to the conclusion that the pleadings that are raised by the plaintiff do not fall, the scope of adjudication in Order 7 to 11 is limited, and the grounds that are raised by the plaintiff, defendant, do not fall within the same. The court observed that the plaintiff shows that there is a clause of action and a right to sue. And further, the aspect of limitation is a mixed question of fact and law, and accordingly dismiss the IA. Next parallel, counsel appearing for the petitioner submits that the court ought to have considered the application in its proper perspective. He submits that when, for an agreement of sale of 1999, when the suit is filed in the year 2019 with an inordinate delay, the court ought to have considered the relevant facts, and particularly that the suit is barred by limitation. Just like that, in a mechanical manner, the court had dismissed the application, stating that it discloses cause of action. He submits that the parties are governed their pleadings, and any amount of evidence adduced beyond their pleadings cannot be considered. And even on the merits of it, if the evidence has to be adduced, they cannot go beyond their pleadings. All these aspects should have been considered by the court. He submits that the court fee that is paid is also not sufficient. Next paragraph. When counsel appearing for the respondent, plaintiff submits that it is the case of the different plaintiff that is in possession of the property, and what has to be paid is only 10,000. The main amount is the major amount is already paid. He submitted that a question of the limitation is a question of fact and law, which has to be adjudiced by the court, which has to be decided by the court by way of a full-fledged trial, and the same cannot be decided at the threshold. The court had rightly dismissed the application, holding that is beyond the scope of Order 7 to 11. Next paragraph. Having heard the counsels on either side, where is the material on record? When an application is filed under Order 7 to 11, the scope of inquiry is the court looking at the three governments alone has to decide the same. The court cannot look into any other documents. In this case, no doubt the agreement of sale is of the year 1999. Suit is filed in the year 2019. According to the plaintiff, is in possession of the property, and substantial amounts are already paid by him. According to him, continuously there was a persuasion by the plaintiff asking the defendant to execute the sale deed, and there are even the elders are also involved in it. Now, whether the suit is within the limitation or not, in that regard, an issue needs to be framed, and the parties have to adduce necessary evidence. Thereafter, the court will be able to decide the same. At the threshold, on this ground, this court cannot non-suit the plaintiff, and as the said issue is a mixed question of fact and law. In that view of the matter, this court finds no reason to interfere, accordingly dismissed. Yes, next.
The main suit is to be disposed of.
Which year is the suit? 2019.
Uninfluenced by the observation.
Next, any of the observations made by this court or for the purpose of disposing of this application, and the trial court shall not be construe this as an expression of this court and shall dispose of the matter as per the in accordance with law. Yes.
Number 18.
Yes. Who appears? Yes.
Regarding rejection of a claim, since it is barred by law, because any alienation made prior to 2005 is protected. And yesterday they have submitted an apex court judgment to lodgers, wherein the issue was regarding the partial rejection of claim. And a number of judgments are regarding the combination of a cause of action as well as a partial rejection of a claim. But in respect of the barred by law, along with partial partition, there is no judgment per se as such.
Even the judgment that he is relying on?
That is regarding.
Let's read it. Let's read it.
That aspect was basically on the cause of action.
No, let's see that. It's on the cause of action also.
Yes. And the other question was also regarding the legality of rejection of claim in a part also. And it is a settled law that a partial rejection of a claim cannot be done as such. But
no, it is on what ground? I'm looking at this case. The 4 years after the suit was instituted, the defendant filed a petition seeking rejection of the claim, while the trial court dismissed the application on the ground that the plaintiff does disclose the cause of action. The High Court, by the impugned order, observed that the property in survey number 76.1 was sold way back in 1999 via registered sale date. The High Court reasoned that the plaintiff did not deny the sale, but only urged that there was a subsequent reconveyance of the property. So, this is also with regard to a particular property, like how your case is. Without a corresponding mutation, High Court proceeded to allow the application under Order 7 Rule 11 in part and rejected the plaintiff with regard to Schedule A property. See?
But again, that was the reason why they agitated was.
No,
there was no cause.
It is like this. No, it's whether it is a cause of action or any other ground. In the light of this judgment, part rejection is not permissible.
If what they can leave out these two property and proceed in respect of, because when you read this claim to lodgers, out of 12 properties, major portion have been sold out way back in prior to 2005, and there is one property which has been sold in the.
Any order is granted?
Please.
Any injunction is granted? No. So you are at the same place. Let it go on. Agreed with the orders passed, and where is that order? Impugned order.
Impugned order is of page number 11, 22.
Page 22. Where am I looking?
Page 22.
Agreed with the orders passed, and I number. What is the I number? Agreed with the orders passed on an application under Order 7 to 11, dated 30th January 2023. Your defendant number?
Defendant number 14.
Defendant number 14 is before this court. The respondent's parent had filed a suit.
Respondent 1 to 7.
1 to 7. Had you appear for them? Respondent 1 to 7 had filed a suit to award to the seeking partition and to allot 1/3 share to each of the plaintiff for means and bounds, and also to declare that the sale deed dated 28/4/1983, two sale deeds, 21/4/1984, 29/8/1985, 17/5/1990, 28/5/1990, 3/3/1992 and 1/7/2020 are not binding on the plaintiffs. The defendant number 14 had purchased the property by sale deed dated,
Who says this?
that is 28/4/1983, has purchased the property by way of by sale deed dated 28/4/1983. Then he has come up with the present IA seeking rejection of the plaint. It is a case of the defendant number 14 that when the property was sold in the year 1983, filing the suit in the year 2020, seeking cancellation or seeking a relief that they are not binding, is barred by limitation. As far as the suit with regard to the sale deeds pertaining to the defendant number 14 needs to be rejected. The plaint needs to be rejected as far as the relief that is sought. Again, it's the sale deed dated 28/4/1983.
21/4/1984. 21/4/1984, and another second is 29/8/1984.
21/4/1984, sale deed dates, sale dates, and 29/8/1985. 1985. The said application came to be dismissed by the trial court by order in June, wherein the court had observed that the suit is a comprehensive suit for different reliefs for many properties. On going through the entire material, to decide the dispute between the parties, full-fledged trial is necessary. So it's not proper to reject the plaint technically, as such the application filed by the defendant number 14 appears to be premature and accordingly dismiss the same. Agreed thereby that defendant number 14 is before this court. Then counsel appearing for the defendant number 14 submits that when the court is satisfied that a particular cause of action is barred with a limitation, and in respect of the same, the court can partially reject the plaint. He had relied on the judgment passed by this court, the coordinate bench of this court. In case of Muralidhar and others, versus Shweta and others, arising out of civil revision petition number 100136 of 2022, dated 29th March 2023, wherein the court has set aside the order of the trial court when a similar relief of this nature is sought, and the plaint was rejected as against defendants number 2 to 6 in respect of item number 1 of the scheduled properties. Land counsel relying on this judgment submits that this order submits that the court ought to have rejected the plaint as far as defendant number 14 is concerned. Next one. Land counsel appearing for the respondent plaintiff numbers 1 to 6.
1 to 7.
Respondents 1 to 6.
Is 1 to 7.
1 to 7 submits that a partial rejection of a plaint is not permissible as per the law laid down by the Honorable Apex Court. He relied on the judgment of the Honorable Apex Court in case of Kumari Gita versus Nanjunda Swami, arising out of SLP civil number 8147 of 2016. This is civil appeal number 7413 of 2023, wherein he had relied on paragraph number 11 and 12, wherein the Apex Court has observed that the High Court committed an error in rejecting the plaint in part with respect of Schedule A property and permitting the plaints plaintiff to prosecute the case only with respect to Schedule B property. This approach, when considering the application under Order 7, Rule 11 is impermissible, and accordingly set aside the order of the court. The court also observes that not itself. Basing on this judgment, and counsel submits that the court had rightly observed and dismissed the application. Next one. Having heard the counsel funding the side, there is some material on the court. Then according to the context of the counsel that the claim can be partly rejected as far as the petition before this court, that is, defendant number 14 is concerned. He has relied on the judgment passed by a learned single judge of this court. Then the counsel for the respondent is relying on a judgment of the apex court. In case of Kumari Gita referred Supra, in the light of the law laid down by the apex court, that partial rejection of the plaintiff is impermissible. As such, relying on considering the judgment of the apex court, this court is of the view that the trial court had rightly rejected rightly dismissed the application filed seeking rejection of the plaintiff, and this court finds for legal statement.
Regarding the merits of the observation made in this, regarding the observation made,
See, that all the disclaimer should be there. Yes.
Serial number 73, kindly let it taken up tomorrow.
Tomorrow, but what about the title?
I have informed him.
Tomorrow he is asking for. So we'll sign it in the chamber because there are some changes in that.